Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning, everybody. How are you doing today? Thank you, everybody, so much for joining me. I'm so glad to have you here. It has been a morning, and I am all ready for Miss Karen Reed. Here we go. I want to welcome you. Please forgive the duck mode. I woke up at 6 a.m., somewhere in between there with a migraine. And so the headache is all but gone. I've been working feverishly to get rid of it. But I don't want that big main light up there to trigger it to come back. So for now, we are just doing dark mode. That's why I have the candle lit with Hamish back there. I remember we have Heidi the Highlander and Hamish the Highlander. So we are waiting for a Reed trial or hearing. This is going to be interesting and a doozy. So yesterday we had, um, of course, my dog starts to drink the water as soon as I go live, so if you hear it, I apologize. So, one of the things that was yesterday that they discussed was the payment for the, expert witness yesterday, and I was thinking about that, and I was kinda like, you know, I don't understand why they're making a huge deal out of it. I get to a point the importance. I understand that, I'm sorry, I'm having to get all this stuff set up. There's a lot of background work I do once I go live, pop out tabs, things like that. But um, the situation concerning the payment, if the attorney paid, hi, Angela. If the attorneys did pay, the witness after they testified, that is not a huge big deal. I mean, they do that all the time. So why is everybody having a coronary over it? Well, the way it was presented and the way I saw that in court was it was being presented that it was done prior to testimony. And I get what Yannetti was saying. Yannetti was saying, hey, we did not pay you for your services. We didn't hire you. You were hired by another organization, not by us. You did all of this work for per another organization, not by us. We did not ask you. We didn't hire you. We did not seek you out. So we'll see what Auntie Bev does. I just think it's deployed by the defense. I mean, the prosecution to trick him up and get him in trouble. And it's Prosecutor Brennan. There you go. Auntie Bev and Prosecutor Brennan. That is so true. That is where we are. Um, so, oh, I just pray this headache continues to go away and does not come back. It will not be fun if it does. But that is why I am in the dark. So thank you guys for your understanding. If you are um inclined to do so, please click the like button. Um put I shared. If you shared the live, please do so. I do have a drawing at the end of the day for the entry for the $50 gift card at the end of the month. We are away, minutes away from the Karen Reed trial hearing, motion hearing. I keep calling it a trial. My bad. Thank you, prosecutor. Prosector Brennan, not prosecutor. Prosector. Ah, hey Jess, welcome. Everybody, welcome and thank you for joining. I really wanted to dive in deeper, so we'll do it later during the breaks on what happened yesterday. Yesterday was interesting. Okay, let me see what this is. And then we get on stage. Yes, they have a new feature. Oh, that's not what I need. I'm working out a new feature. There we go. In my StreamYard, they have a place for set up scenes now, and that's very new. So I have got some toggling I'm learning to do. So forgive me. Latest and the king of kings of mistakes. There's another misspelling. Where? Did I misspell something again? Oh, I hope I didn't misspell something. Hope not. I can do that, guys. I am very dyslexic, so there you go. I will be snacking. I took medicine, so I gotta have something in my tummy. Mm, sorry. Oh, Brendan misspelled something. I have never seen so many typos and errors. Sensei, no, go. I have never seen so many typos and errors in court documents as I have in this case. I know these documents are flying off the shelves as quick as they could get them. I get it. Um, yes, Yana, I'm okay. Um, just fighting this migraine, trying very hard to keep it at bay. It was a raging 8, 9 this morning, about 5:30 this morning, nausea, dizziness, the whole shebang. And I still have a little bit of a optical migraine going, which means part of my vision is affected. Hence why I'm in dark mode right now. So thank you so much. If this is uncomfortable for you guys and I really need to turn the light on, just let me know. I'll turn the light on. I'll put sunglasses on if I have to. I prefer not. So if this is okay, I appreciate it. You spelled process. Oh, I got you. Thanks for the clarification. See, my you, migraine fog, y'all. Prosecutor's person who is preparing a dissection of demonstrations, usually a medical school or hospitals. Yeah. Okay. I do want to talk about that because one of the things that they're fighting over is the admission of experts. And in the world of the experts on the medical side, I had somebody comment yesterday evening when I was not live, wanting to know what my qualifications were for me to be able to dissect and explain what I did yesterday. And that's this: I was married to a physician. I have worked very close in the physician world. I am a first responder. I do have more experiences, but I will tell you, I do know the difference. And for someone who is a neurologist cannot be acting as an expert and declaring the cause of death. That is an ME, forensic pathologist. It is not a practicing clinician. Now, they are not also um, skilled or experts in reading all of the information from autopsies, toxicology, the forensic photographs, the information from the investigators, dot, 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 and then determining a cause of death. Now, what a neurologist clinician can do is they can explain how the brain reacts to trauma. That they can do. For example, when you get a blunt force trauma to the brain and the brain starts to swell, and without medical intervention, if it is bad enough, the brain will continue to swell to the point that it starts pushing down on the base of the neck, the brain stem, pushing everything down into the base of the brain. I'm being very general here, which will cause the body and the brain to stop communicating and cause death. Very, very basic explanation. I can go deeper, but I don't think I need to. But the point is they can say brain injured here, brain reacts this way without medical intervention, and sometimes even with medical intervention, the brain will do X, Y, and Z, and death can occur. But they cannot come on the stand and say, as an ME or a clinical, I mean, a forensic us um, pathologists that that was the actual cause of death. And that is something that I think is what the fight is over. If they were going to just bring him in as a neurologist and have him explain what blunt force trauma does to a brain in a living person, I think that would be fine. But we'll see what Auntie Bev decides. All of my mods, especially my research mods, please be on the lookout for any and all decisions that come down today. Oh, the meteorologist is the next one we're going to talk about while we're waiting for this trial to begin. The meteorologist is someone who studies weather, not the earth and the ground. The meteorologist can come on and say, hey, the day before, the day of, and every hour of that day, and then after, this is what the weather was doing. This was humidity. This was what the winds. This was what the snow accumulation was. This is what the barometer is. This is what was anticipated. And this is how cold it was. And then you can bring in a geologist who can come on and talk about the earth and how that weather could affected the ground and the earth. And then you can bring in a neurologist who talks about the brain and how a blunt force trauma can react to the brain. And you can put all that together and then bring in your ME or your forensic pathologist, and all of that together in that manner can be done. But you cannot bring in a meteorologist to talk about the ground being hard as a rock. That is a layman's term. That is not scientific, and his methodology is not there. That is one thing that we are hearing a lot in this case, and that is methodology. What is methodology? Is the way in which you come to your deciding your decision. How did you get from point A to point B? What's the method you use? And is there scientific backing for that method? They're fighting between Dr. Russell and, oh my gosh, what is the other guy's name? Is it Wolf? No, whoever the neurologist was. Um, you know, I I am very for Dr. Russell because I understand her qualifications. I understand her amazing, amazing background. For those of you who missed it, Dr. Russell used to be went going to med school, became going to college, um, wanted to become a doctor, if I remember it correctly. Her mother got ill. She became a cop. She worked as a police officer for some years while going to med. Thank you very much. While going to med school, or I don't know how many years. She wasn't a cop for super long time, but then went to med school. She has been an emergency room physician, an attendee, and she has been the top of all the emergency room doctors. She has been the chief of X, Y, and Z. She's done forensics. She's done ME. I mean, she's got a litany of list of qualifications, and you can't argue that list of qualifications. You really cannot. Yes, I'm going to have to snack through the day. I took some pretty pungent medications to be up and alive for y'all today, so please forgive the munchies. Can't help it. Oh, yeah. She took in her nephew and niece. So, the thing about Dr. Russell is even though she hasn't physically practiced in a few years because she's retired, she still is involved in the behind the scenes running of a lot of the departments. She's still up to date. And on top of that, she's a bite expert. She's written several medical papers that were peer reviewed concerning dog bites. Now, originally, they were geared towards our police dogs, but That said, she knows a bite. And when you are asking a physician, or if you ask any physician, what field of medical study? What I mean by that, emergency room, internal medicine, OBGYN, podiatry, pulmonology, radiology, oncology, urology, all the different specialties of medicine. Which one will have the most experience and exposure to a dog bite? Which one will have the most experience to dog bites? It's not your medical examiner. Every once in a while, if someone was unalived by a dog, and it's not your family practitioner or your primary care physician, it's going to be your emergency room doctor, which is what she was. I've told the story where I had a flying squirrels as pets. They were awesome. And I thought I had 2 female. That's what I was told by the breeder. Well, I had a male and female. At some point, the female became pregnant, and I went to pick her up, and those hormones were flying, and she just bit me and clear through at the back of my thumb. The bottom here, the top here, you heard the crunch, and that tip of that thumb could flex. If I hold my thumb here, I could bend it. And it went through the nail all the way to the bone. It was so painful. And so when I went to the ER, I saw the regular ER doc, and then all of a sudden, this big man with this wiry beard, he was wearing Crocs. He looked like he just crawled out from the forest and put a doctor's coat on. And his hair was kind of wild. He goes, "Who has the bite? Flying squirrel. I've never seen one of those." And I was all like, here? He was a bite expert, and he was so excited. Didn't matter what the bite was, didn't matter who caused the bite, human, animal, preferred animal. He had to see it. He documented it. He photographed it. He asked me to sign for him to keep copies of the x-rays. I said, sure. I didn't care. And so there are people out there like that. She was the dog expert. She had seen many a dog bite. So for them to try to bring on this other person who has no veterinarian or medical experience, who used to be a police officer, who became interested in dogs and dog training. He is a self-claimed dog training expert, a behavioral. That's it. That's what I'm looking for. Self-explained behavioral expert to come on. And what? Attorneys are on their way. Live court will begin in about 45 minutes. Of course. Oh, my screen is not in the right position. There we go. I bumped it. So you have this person who really has no medical or forensic knowledge coming in and saying, okay, let's anesthetize the dog that we declare is Chloe. And number one, I want to know how you know that's dog. I want to see photos of Chloe before. I want to see photos of the dog that you anesthetized. Is it chipped? If it's chipped, I want to see the chip number before it was the day of the unaliving of John O'Keefe. And I want to see the chip information the day you anesthetized. I want to make sure they can do that. They have records of all that. So if Chloe's chipped, get the chip number from the vet, the date it was put in, and then also match that chip. And then I hate that they, outside of a medical procedure for for the well-being of the dog. They anesthetize the dog, which is a risk. When you anesthetize an animal or human being, there's always an inherent risk that that animal or human being may not wake up. There's no guarantees. And you sign that away when you go into the hospital and they go to anesthetize you or put you under for a procedure. You have to sign acknowledging that there is a risk that you're not going to wake up. So with that, they anesthetize a dog unnecessarily for any medical reason because they want to get a bite impression and to measure between the canines. That to me is wrong. I don't like it. I don't think it's right. I don't think they should have done it. And then you have them comparing the measurements between the canines and they make a mold of the dog's bite and they try to impose it over the picture of an arm stretched out on a gurney of the decedent and try to say that this does not match. Well, first of all, flex the arm like I did and look at the puncture patterns and you can see where it looks like it was one of these kind of bites. Number one, if you believe in the dog bite pattern. Number two, I agree with the defense in the fact that you can't take a non-stationary event. When a dog bites, you pull, there's movement. Even in just the dog's bite itself, there's movement. Even if the arm didn't jerk, the dog bites and closes and pulls. That in and of itself is not a linear situation. It is a three-dimensional moving environment. And now you're taking molds of a dog's teeth years later, which, by the way, dogs' teeth, just like humans, do shift over the years. The niece and nephews were John's children, and John is the one who took care of his niece and nephew. You are correct. So what happens is they decided to take these bite molds and the measurements and lay them on top of a flat photo and say they don't match. We're also not taking into account the curvature of the arm, the fact that the skin dimples when you push on it, which distorts the bite. The only way you can appropriately try to match it is before the burial or the cremation of a victim of a dog attack. You then take the molds of, if the dog is alive, take molds and then you go and you superimpose them physically on the skin and push and do all that. They're not going to do that. So to me, this guy's theory and all of his stuff doesn't hold water. In all honesty, out of everything in the Karen Reed trial, the dog situation to me is the least of what I'm concerned about. I understand that people want to explain the arm like crazy. I just wanted to make sure my candle wasn't getting hot for Mr. Hamish. I understand that. But to me, what's more important that's not being talked about, that should be talked about more than the dog bite, is the blunt force trauma on the back of the head. Now, as I spoke about yesterday, I said yesterday that they're going to bring in this meteorologist to talk about the ground was hard as a rock, how that's not possible. But what is hard as a rock that's around that victim at the time? Fire hydrant, electrical box. The fire hydrant, to me, I would have immediately covered that baby with a bag. I would have had it processed if need be, have it removed. They can do so by keeping it covered with a bag and remove it and have it replaced and take that back to the lab and process that for DNA and any kind of skin tissue, DNA, any kind of blood, all of that I would have had processed. They didn't process it at all, at all. And I'm like, why? Now it is so true that when you pull up Google Map, 34 Fairview is blurred out. I'm going to share this. I'm going to get us up here on stage. Look, it is blurred out. But what's not blurred out is this fire hydrant. That fire hydrant right there. And John O'Keefe's body was somewhere in this area right here. Okay. So why are we, hold on. I don't want to go that far. I want to go there. There's the flagpole. Here is the electric box. Here is, come on. You can see the electrical box right there. Here is the fire hydrant, which looks like it hadn't been used in 20,000 years. And here's a flagpole. One of these two things could have caused a blunt force trauma on the back of the head. And unfortunately, they didn't process. Oh my God, I didn't just see you take a bite of that, Diane. When I am sitting here, Diane is our fabulous interpreter for those of you who don't know. So anyway, they did not process the electric box, nor did they process that fire hydrant. Now let's just go with the state's theory. Say Karen Reed is parked right here, and she backs up and hits O'Keefe. He flies backwards using his elbow to break her taillight. He flies backwards and he lands on, come on, this fire hydrant with the back of his head. If that is what happened, which it could have, then that trauma of his head hitting the back of on that fire hydrant could have very well caused the blunt force trauma to the back of the head, and then the brain swelling and everything else could have caused the black eyes. All of that is plausible, but nobody is thinking about these two devices, even the electrical box. Now, the electrical box, I'm not as strong of a theory on that because that metal is thinner and would give, and you would be able to see the impact if it was hard enough to cause the damage to the skull that was caused. I can't seem to get a good angle of that box, but there it is. Let me zoom in. There we go. And if you notice, that box is open and has been open. That's the way it was that night, actually. There's a photo with it. So when you see this box, it's not very strong. It's kind of flimsy. So if his head did hit that, I would think there would be some evidence, but maybe not. But it's either one of those two things.
Ladybell.
And neither one of them was processed. I struggle with that. But once again, I hate the fact that they have blurred out the house. And they blurred the house across the street, both of which are police officers. This guy over here is where the red Solo cups came from. And if I remember correctly, if I'm correct, he was a police chief of Boston PD. Or assistant chief of the Boston PD.
Excuse me, got to put the fur baby out.
That is my story. I'm sticking to it. I firmly believe that there is I'd be blurring all of their houses out if you're going to blur one. But this is, to me, more of a potential culprit for the blunt force trauma to the head that can cause the kind of wound that he had. And it's closer to the road as to where he was found. No, actually, I think he was found right here. He was found right here. Much closer to John O'Keefe, especially if he's standing somewhere right in here. He falls backwards, hits that, he rolls around, he lands where he did. I don't know. That's my humble opinion. What are your thoughts? What do y'all think about that? Oh, that's right, I gotta keep her up. Let me go ahead and get to this, put that back on the screen. I'm gonna get rid of 34 Fairview. So, there is so much that they've not explored, and the other fact that they did not go into the house, they didn't get a search warrant, they didn't look at the glasses in the house to see if any of the drinking glasses, i.e., alcohol, whiskey, bourbon, scotch glasses, could have matched the one that was the fragments and charge that were found on the back of Karen Reed's car. So for me, that is my question. Number one, the fire hydrant. Number two, why did they not get a warrant? Why did they glasses go downstairs? Why did they not talk to the son? Why did they not investigate where's the dog? Because everybody knew they had a dog, and that dog was somewhat protective and aggressive. The dog was rehomed after attacking two women walking their dogs on the street. A lot of unanswered questions, especially since we've already had a trial, and now we're having all of these unanswered questions. I was hoping we would have more questions answered. Today, central Wisconsin, yesterday spring, today blizzard. Half of the schools are closed, other half are online learning day. FYI, when I say blizzard, I mean winds blowing over 40 miles an hour, even though there's only a few inches of snow. The wind will cause white-out conditions. Also, it's almost 50 out yesterday and raining. Today, it's 30. It is an ice rink out there, and I'm not going out. I don't like ice. Dawn Ellen. I'm with you on that, babe. Yesterday, it looked like we were in a dust bowl. We had so much dust and stuff blowing around. We had reported gusts of winds up to 55 miles an hour, some places 60. It was awful yesterday. Thank God we had no major fires, but we did have somebody do a burn, and it was uncontrolled, meaning they weren't there watching it. In these conditions, they decided to burn their burn pile. I'm like, what? If you live in the country, a lot of people burn their trash, certain trash, and that's all fine and good. But you also know what days you can burn and what days you should not be burning. And they were burning on one of the worst burned fire days we've had in years. I think it was 20 years since we had conditions, all of the conditions line up the way it has. So, yes, we are on a court delay. Now they're saying it's going to begin about noon Eastern. The attorneys are on their way. There is something holding them up, but guess what? That's what it is. Let me see. I might want to, let's just go back and look at a few of moments of court yesterday. Oh, that's not what I wanted to do. Work with me. Work. And thank you guys for being patient and understanding with me. This headache is going to keep me under a little bit today, so my apologies. I want you to see what I call the smackdown by Auntie Bev as soon as court started yesterday.
Or misrepresentations. You speak for the entire defense team. You already know that. Do you understand that, Mr. Unity?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Leslie?
Yes, Your Honor.
So each attorney is legally accountable for the actions and statements of the entire team. So now the questions that I have, Mr. Leslie, that you said you welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you call it. Could you stand, please, because I am going to address you.
Yes, I was gonna go to the
Sure,
podium.
go ahead.
Thank you. I didn't want to stand when you were talking.
You could stand. All right, so the pause email is you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Renschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email.
Michelle, you heard?
Sorry about that. I got an important call from my daughter. She got her first job. Needed information.
Good morning, Your Honor. Ron McLaughlin, for Commonwealth.
Good morning, Mr. Blackwood. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Jessica from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of the street.
Good morning, Mr. Hill.
There we go.
Morning, Your Honor. Robert Alessi for Ms.
From
Reed.
live court.
Mr. Leslie.
And good morning, Your Honor. David Kennedy for Karen.
Okay,
Mr. Nettie. Good morning, Mr.
watch the attitude.
All right, so we've got a few things to cover today. We had a couple of questions to finish off about the defense position on the opposition to excluding the ACCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under DAGA grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the tapes of the Canton Police Station video. So that's the order that makes sense to me to finish up what we already had scheduled last week before we do anything else. So the questions that I have. Before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you act for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Yannetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Leslie?
Yes, Your Honor.
So each attorney is.
Okay, this was a judge disciplining very gently the defense team because they are doing this going on, and it's like, It doesn't matter that they're in different offices. It doesn't matter that each attorney is in different parts of the country. If one makes a mistake, the mistake is by all. If one says something out of place, it's said by all. You can't sit there and say, well, you know, they didn't mean to do that. They did it. I didn't. So don't get mad at me. It's the whole team. Doesn't matter. It's all for one and one for all, is what she is saying. And so um, I was a little surprised to see this. She comes in loaded for bear yesterday. This is day one. We're recapping a little bit. We're replaying it, waiting. There is a delay. The court will be starting at 12 Eastern. Something going on. The attorneys are on their way, is what it says.
Legally accountable for the actions and statements of the entire team. So now the questions that I have, Mr. Alessi, that you said welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you call it. Could you stand, please, because I answered your question.
Yes, I was gonna go to the
Sure,
podium.
go ahead.
Thank you. I didn't want to stand while you were talking.
You could stand. All right, so the pause email is you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your Dr. Wrench.
I want to catch that date again. March 20th. So on March 20th, they are telling him, send us your information. We will get you the retainer. I think that this is being made a huge deal over nothing. In all honesty, if I'm sitting on the jury, of course, I guess those of us who are watching this kind of stuff all the time, we understand the processes. When Mr. Yannetti, sorry, I think it was him, asked Mr. Wolf from ARCA on the stand, have we paid you? Did we hire you? Have we met in person? Have we done this? And no was the answers. I think it was truthful in the sense that it was really a thin line for him to walk because of the fact that Mr. Wuss was originally retained by the FBI to perform the investigation that he performed and come to the conclusions that he came to. It is common and expected you pay your experts for their time and retainer to come to trial, and you pay them for their travel and all expenses. So if you separate the two, I don't see a problem because he wasn't paid until after trial. I think part of the problem that Auntie Bev is having is the fact that there's an email in March stating that there would be a retainer. I think if Mr. Yannetti could have gone back and switched that and said, we have not paid for your investigation. We did not pay for you to come in and do all this work. You are being compensated for your time here today, but your testimony is based on information that you gleaned from being hired from another agency. Is that correct? I think that would have negated all of this. Unfortunately, that's not how it was asked. And then we got Brennan being a little peapot and trying to cause as much destruction and distraction as possible.
to be
And,
very
and I believe they're going to get sanctioned for it.
required. Also, if you could attach a copy of your, Dr. Rentschler's and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again. Agent.
Standard.
Then
That is a standard letter that is sent to anybody who's going to be testifying as an expert at a trial. What's the problem? Guys, this headache is trying to come back. Come on. I don't need it.
as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARCA and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls?
He's going to
Do you know that to be fact?
was not
Or is that what you are inferring, as you said?
I am inferring, Your Honor, I do not know that as a fact.
Okay. So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time
Same time as what, Your Honor?
as the invoice?
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, on the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your
Go ahead.
question. I learned.
Okay, so he is already getting a little titsy with her. Have you ever sat there and somebody keeps throwing questions at you and you want to answer them, but you can't because they won't shut up? That was what you just witnessed. And then she's like, why aren't you answering me? And he's all kind of like, because you haven't shut up. Now I can answer you.
That invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned.
You don't have to.
I'm sorry.
repeat it. And again, what you know and what all council know is one and the same.
I understand, Your Honor. And I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through. And when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
He's an analytical minded man. He likes to lay his dots. Take that and eat it. I was getting ready to say that, Rhonda. He likes to lay his stuff down very methodically. Clearly, 1 leads to 2, which goes to 3, which goes to 4. He doesn't like to go 1, 2, 5, 6 and skip in the middle. He wants it very clear, organized, and precise because a life is on the line on this. And Auntie Bev, sometimes she'll ask a question and then she doesn't want to wait to hear the answer. She wants something precise, yes, no, done, out the door, when it's not that kind of an answer. This whole thing about the payment is a timeline issue. Everything's timelined, and that's how he's looking at this. Unfortunately, Auntie Bev doesn't have the patience for a timeline.
The motion, defendant's opposition to the Commonwealth's motion to exclude employees of ACA is signed by you.
Your Honor, it is signed by me, but if I could, with regard to 3.3A1.
No.
3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So
Yes,
respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. In something that critical of candor to the court, that's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate.
Mic drop. Mic drop. Sounds like a frustrated mom with too many teenagers laughing around. Yeah. Mic drum. Do it again, Sam. It's not a mic drop, but that's the closest I could get. He is actually correct. If you have 4 attorneys and attorney number 3 says something wrong, and you know that there are misrepresentations happening, and then you don't say anything, yes, you were held responsible. Now, if there is something that's said and it's a misrepresentation and you were not aware of it being wrong information, then you are not responsible. And Auntie Bev knows this. She's like pissing in my Wheaties today. This was yesterday.
So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
Yes, he just put her in her place.
All right. I'm not going to ask
Back
that.
down.
All right,
I'm not going to
so let's
respond.
move on to the next motion.
Your Honor, if I could.
Okay, right here. She knew she had a smackdown. She was put in her place. Yep, Diane, your sign is almost off the screen. I'm sorry, babe. There you go. Yep, you're good.
Dr. Entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. Your Honor well knows the inquiry under Dalbert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established.
How long do you think it'll take to
Hold on, I'm sorry, Diane. Hold on.
He provides
I was trying to zoom and I accidentally put it on the wrong speed. My bad. That's not fair to you.
zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study. He doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor.
Case in point, it is the burden of the prosecution, not the defense. Everybody's forgetting that. Even the jury. The jury wanted answers. They wanted clear-cut answers, and there was reasonable doubt across the board, but the jury themselves did not understand that said reasonable doubt. And that is frustrating to me because I've listened to the one juror who has gone on and spoken many times, and he's sitting there saying that there was doubt. It wasn't clear. And I'm like, then how can you be hung on count 2 when there's reasonable doubt? When you have reasonable doubt, it goes to the defendant. It's not the defense's responsibility to answer the who, what, when, where, how, and why. It's not their responsibility. The prosecution has to prove beyond reasonable doubt. And it's really hard because the juror said that they knew she was there. They knew he had something wrong and that he passed on. Diane, I'll take you off for a minute. And they knew that somehow something happened and she was there, and that's what some of them were stuck on. But that's doubt. He said there was nothing but reason. There's doubt. I think jurors get hung up on that. And the other thing he said is that it was not made clear that they could find unanimously on counts 1 and 3 and not on count 2. They would have reported counts 1 and 3. So let's listen some more. But it is not for the defense to prove this at all.
That the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That
They did not, in this report, clearly explain the method that was used other than anesthetizing the dog, getting a bite mold, and measuring the teeth, and comparing that to the defendant's arm. That doesn't make sense. And that is not a scientific methodology that's recognized.
dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was, for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used that are called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission, the Commonwealth put in, very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2
Okay. I just looked up something. The sign method usually is way or how something is done. But in the court proceedings and in this way, it's technical way. Technical way. It's technically how this is done. I'm not teaching Miss Diane. I'm just explaining our differences because I signed it one way one way or another. I'm gonna find ya. Never mind. Get you one way. So anyway, somebody asked me yesterday that I was signing one word. I think it was method one way, and Diane was signing it another. Also, in American Sign Language, it is a translation. It's not a word for word meaning concept. So I just wanted to explain because I was asked.
You apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with two parts, is a questionable methodology. He doesn't employ the overlay method, the part two. So the molds that he took are mean.
So remember that I stated when we started this topic that you have a linear and you have a three-dimensional. He's talking about a three-dimensional. Do you know those ballistic body that they use when they investigate the path of a piece of lead coming out of a lead shooter? They can do the same thing with an arm. They can take the arm, they can basically transpose an image on the arm of the wounds, and then they can go in and make those wounds on the gelatin arm. There is a bone, a chicken bone or some animal bone inside it, and then it replicates the arm. They can transpose the image to the arm. They can recreate the wounds. And then it's a three-dimensional. It's pimpling, it dimples, it's malleable like a human arm. Then take the bite mold and compare it. They can't do that. They didn't, and they cannot. Because now the decedent is gone, buried, and the only thing they have are images that were of a side view taken at, here's the arm, it's taken at that angle. You would need a perfect picture from the top, from the sides. They didn't photograph it in a way that they could reproduce the injuries. Thank you, David. Hi, June. Thanks for lurking. He has a good argument here. And I think some people got lost in his argument, but you can't take something linear and make it 3D.
Meaningless unless you have the overlay to go with it, because that's what you compare them to. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists. And even then, the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides zero citations, and the Commonwealth provides zero support for taking measurements in molds and comparing them to the wound. Zero. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in the defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine. But the fact is, her main point is he never accounted for that in his methodology. It's not an opinion. It's a methodology. So, and again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support, but he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him.
Okay, this is the first time, including since trial, my mic was almost unplugged. That was weird. This is the first time I have really heard an attorney highlight the bent arm theory on the bite. They glossed over it in the first trial. But it is true. I took the photos. I separated the forearm from the upper arm. I bent it together to make it look like like he's like this. And when you put it in that position and you look at the punctures, you can see two sets, like it went chum chum of punctures. And there are scratches, which would happen from the other teeth. So he is the first person to really explain that. And I think he did a good job.
She also states that the photos that he used,
I'm going to take it
there's no
right back.
documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained. They have to give a fair and accurate depiction. And you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My God, she had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin, human skin. When there's any pressure, particularly with a bite, it moves, it dimples, it hits the muscles, etc., etc. He gave no account for the condition of the human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So, with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. what I found is particularly probative of the issues I just raised. So I looked at I read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about
FYI, Karen Reed is in the courthouse. They're waiting on the cameras. We should be up any minute.
on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology.
Congratulations.
What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is now one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability there is.
Okay. We are getting ready for Karen Reed today's trial. So we're going to take a break from this. Miss Diane can take a little signing break. How you doing today, love?
I'm doing okay, but my lunch hour, half hour is about up.
Well, I got to say, your hair is looking cute. It's getting long.
Thank you, thank you, thank you.
Yeah,
It
I
is
can't get
getting
my
long.
hair to pile up on top of my head and look that cute.
Well, your hair's a whole lot thicker than mine, darling.
A whole lot longer and a whole
And
lot.
a whole lot heavier.
Yeah, that's true. I won't deny that.
That is for sure. My daughter is on a cruise ship with her husband and 3 girls.
Lucky her. Never been.
Well, they were going to go to Cancun on an inclusive, but she was so sick with bronchitis, they had to cancel that. So they opted for a cruise ship when she got better. So they're having a wonderful time. So, isn't that great? I wish I was with her, but it ain't happening.
Yeah, I know. I wish I could. Tracy, my sister, and I were supposed to just week or two before she was diagnosed with the reoccurrence
Yeah.
metastasis of her cancer. We had just said, hey, spring break. And that next March, my birthday month, we're going to go on a cruise. She was getting ready. She was looking into it. And, well,
we're going to do it. You, me, and Marge are going to do it.
we're in court. I got to quit.
We're going to do it. You, me, and Marge.
Sounds like
And
a
is
place.
that Karen Reed?
For those
Karen Reed.
jurors are the court officers in the Department of Security of the trial court in this court.
Something happened. That's Miss Karen Reed. John O'Keefe is, of course, the victim.
Oh,
Dismissed
I tell you
for
what.
extraordinary governmental misconduct, are true and correct to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So
I'm
the
just going to
fact, what you state is fact,
I need to
that
take you off.
Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers and the Department of Security of the trial court in this court.
Mr. Fanning,
So I am going to ask you what your good faith basis is for that, and I'd like you to start there.
If the court,
get behind the
if the court
microphone.
recalls the discussion at sidebar, we were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No,
The,
I didn't tell you about the role. I didn't
I'm
know
getting
who
to
it
that.
was.
I'm getting to that.
You
Because that was
shut
the
up
next
and let him do his
conversation we
job.
had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously
You were not,
recognized
just
that.
so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers. The
Who
court
are in
officer-
charge of the jury?
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what my declaration says,
shut up.
my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time. As the court knows, there was no declaration, there was no report, there was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember. No, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
And
he
I'm
has.
just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is
Woo!
a commander
Nippy.
of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us. We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar
No,
that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Unetti and I asked the court to take evidence from Lieutenant Fanning. The
I
court
think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew.
Oh, she's going to
that he
nail
did
him.
not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
Oh,
Put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's
But
the
did he?
nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
Now
there
that you
evidence
know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly. I take
So
the court
we
at its
will
word. But
move on from that, Mr. Jackson. We'll
but the-
move on
we'll
from
agree
that.
to
So
disagree
the
until I
court's
decide.
asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly witness. I'm sorry, defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason, because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case. And he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly. And the court never even inquired as to why he was the one receiving the report.
Yep.
Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror. That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
All right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
Woo! Yo, this is getting a little bit heated. Yo. She is out for blood. I think that she's upset with them because they are questioning her ability to judge. And she's just fighting everything she can to not declare anything in their favor. Once again, thank you, Court TV, for your feed and for the use of your feed. You guys are amazing. We appreciate you. Appreciate you so much.
Thank you for that. The court invoked Mr. Unetti and said, as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Unetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Unetti. So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
Oh,
I'm happy to, Your Honor, and thank you for giving me the opportunity.
he said, yeah.
The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers through their agents, has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers. But I want to concentrate my argument for the court this afternoon on the exculpatory Sallyport videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sallyport issue, or the Sallyport video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of D. Jim Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious. So he's still around.
He is,
Okay.
yes, and he's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Ms. Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Canton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Sally Port interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sally Port. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sally Port interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D. Giampetro retired, we received four videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment. These are four videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us.
Sorry, I had to get that date.
Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us. That's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sally Port video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. exterior sally port. That means that the Massachusetts State Police not only had in their possession exterior sally port video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 25th. I'm sorry, January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly? Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior sally port video? We now know that Buchnick watched some sort of exterior sally port video. He admits it in this report that we just got 5
Hello,
days ago.
Haley Mounts.
And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior sally port video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute, on April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the sally port. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through
now or no? If you can, if you're going to do it later, that's fine.
I will do it later. I think the
Let
prejudice
him-
is cumulative.
Whoa.
Obviously, we didn't have the information that we needed to be able to cross-examine.
Auntie Bev, stop trying to pressure him to move in a manner that he is not prepared. It is his presentation. You shut up and listen. Write your questions down, and then when he's done, go back and ask. She is trying to rattle him and trying to, every time she asks somebody, when are you getting to this point? I want this question answered. When are you going to answer it? It's always at the most important part of the presentation. Oh, she's pissing me off.
Witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay.
It just very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But in point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the
Shut up.
only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all.
Ma'am.
Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video.
Thank you, Haley.
The opposition says, or reads, the Commonwealth provided the defense with a.
I just always like to read along. Where does it say it? What page
I
you want?
don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs,
Okay.
crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that.
I want you to look at something. Look at him over here. It's like he's praying. He hasn't moved.
The date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived.
Okay, I got to go back. I want to hear that.
Obviously, when it was brought into the Sallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found. Member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. That's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sally Port, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sally Port. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video. It's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sally Port. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there. No, the defense is all wet. They're wrong. They just didn't account for daylight savings time. Oh, no, this was just a little mistake. It's not a big deal. It was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that car was in Michael Proctor's possession at 5:30 and pulled into the Sally Port at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sally Port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it. It's their struggle to acknowledge it. Of course, that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sally Port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally Port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. This is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sally Port videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways. They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sally Port until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sally Port video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581. And this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sally Port where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sally Port? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor.
Okay.
I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish,
Of
that
course.
would be helpful for my review.
I haven't reviewed it, sir, in quite some
That's a
time.
lot of
so I
getting.
can't recall what's on there. Question, why did you review video of the Sally Port? Answer, we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchnick. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight.
Wow.
And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact, by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C, is it Charlie?
Okay.
Oh, she's good.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sally Port at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry.
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, "The quality of the video is poor in certain portions. However, this is the condition it was recorded in." Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably 45
An hour.
minutes, I would say.
All right, so we'll break.
Woo. Y'all. Why do I keep losing my beads? Okay, y'all. This got a little fiery. What you doing, Miss Lady Di? Oh, she's doing something. I don't know. She's something. I want to know what that was. What do you guys think? Andrell, June, Haley, Dawn, all of you guys watching, what do you think? Jesse. Oh my gosh, y'all. Hello, Miss Di. I don't know what she's doing. I'm a little aggravated by the behavior of Auntie Bev, but I shouldn't be surprised at all. I shouldn't be. Auntie Bev is like, can't get this done quick enough. It's very, very rude, and I'm really not liking it at all. She's wanting to cut him short and cut him quick, and that to me is a bunch of BS. But one thing that we've been talking about, we've been listening to, and we've known, as usual, Canoni is annoying me. She has no time for anything the defense says. No, but the prosecution, she's not going to cut into them and they're going to get all the time they want. I'll be shocked if she treats them this way. She needs to be harder on them because they have to prove it. That is something that I keep having to remind myself and other people. So we got a 45 lunch break. Are you kidding me? You haven't even been on this stand an hour. You okay, Diane? Okay, she's getting ready to go back to the other job. Okay, so thank you. I need to remember to turn that off because I every time that goes off, I get in trouble. So Judge Auntie Bev, I'm not going to call her judge. She doesn't deserve it. So I have been struggling to get a clear timeline, and I'm so glad that he stuck to his guns because, as we know, there is a timeline, and Auntie Bev wants him to rush through. 129 of 22 is when the incident happened, and the videos were recorded. There were 4 videos given on October 10th of 24. They received some information. They received a video on April 23rd of 24, I think. And then October 10th of 2024, there was an interior, a main, a cruiser, a church entrance, and there was only one exterior side entrance that was shown, that shown Brian Higgins at Canton PD. No, she's not. She's not. Then on January 20th of 25, Canton PD main driveway side and camera was presented to them, and it was grainy and unwatchable. It was dark, grainy, and unrecognizable. Yeah, I know. Then Sergeant Butnick reported that February 28th of 25, he had a report. And he said on that report in May of 24, I want to see his report, was given a thumb drive or CD to review the video, including Canton PD exterior Sally Port video prior to his testimony. Prosecutors knew of the video before and during of trial. They withheld it. Even this particular part of the video from October 24th through 125. October 2024 through 1/2025. Or now, excuse me, January 25. May of 24 trial, new video that was brought into knowledge was bad and grainy, but it's not the quality of the video that is as important as that fact that there was a video. And Butnick knew about it, Lally knew about it, and the prosecution had signed affidavits that they had given all of the evidence over to the the defense. Yep. They withheld it. And when they did finally turn it over, the video had been prepped and it was inverted. And it did not provide the identifying side of the vehicle of the taillight, which was the right passenger side. And he made it very clear that anything and everything they got, and none of the video showed the right passenger side taillight. None of the video showed it, including the 42 minutes and the inverted video. All of it was the rear left taillight. Are you okay, Miss Diane? You okay?
Celebration of basketball game, Coach Jackson.
Okay. So, all cameras were defective at the moment and the time that the videos that were recording, and at the exact moment that clarity was needed for the defense. And he's right. Some of the video is super clean on this one angle. This one camera was super clean. It was perfect. Nothing wrong with it. And then later on, it was grainy and you couldn't see a thing. And they said they replaced it. I doubt it. All cameras were defective at the moment the defense needed clarity, is what he said. Date of photos. Oh, as they, no photos were taken of the vehicle when it arrived on 1/29/30 to 2 February 1st. So January the 29th of or dash 30 of 22 through February 1st. They have no photographs, only videos. And that to me is insane. They're supposed to photograph that vehicle before they move it, once it arrives in the Sally Port, before they do anything to it, it is to be photographed. And obviously, it was not photographed. They only had the defective videos. And then all the witnesses testified that when they saw that vehicle, the tail light was cracked, not missing or void of shattered, which it doesn't shatter because it's plastic, but broken tail light. Then we have some discrepancies of when did Trooper Proctor actually gain access to the vehicle. It says the car at 4:50, I think 6:1 trooper shows up. At 4:54, another trooper arrives, and at 5:30 p.m., I think they say Trooper Proctor showed or got the vehicle. Then the last team member, I got to cross that, or I won't remember it. It's hard reading in the dark, but I've had a migraine. The last team member arrived on scene was 5:34. Now, the first tail light recorded being found, first part of that cracked or shattered tail light on the crime scene at 34 Fairview was not found until 5:54 p.m. There's a lot of discrepancy in timing. The tail light cracked, not shattered at 5:54 p.m. This is my own thought. Because the videos were not of better quality. Now, this is something I wish I could ask an attorney. Auntie Bev asked him of the videos that were recently presented after Butnick, were they better quality or the same quality that they already had? And he said the same quality we already have. So is that the argument that Auntie Bev is going to use to deny them on the video evidence of a dismissal of trial because it did not help them? You know, I was thinking that if he said it was a better quality, then that would help the defense. But it was of the same quality. So you're not having this video is not going to help you or hurt you in any way, shape, or form. You're not able to glean any new information from that video. That's my personal thought. And I think that's something that she may use. I can't wait to find out, to deny this motion on this ground. Trooper Proctor stated at 5:30 p.m. he took possession of the vehicle. Let me see what I wrote. Commonwealth presents defense not to couldn't. Oh, but then the prosecution says the discretion and the difference of time is because of daylight savings time. If that was the case, it would be a solid hour, not an odd number of minutes. That's my humble comment. Okay. And then Trooper Proctor got the car at 4:12 p.m. and the car arrived at the Sally Port about 5:30. At 42-minute missing video, conditions of the right tail light in Sally Port upon arrival. And I love the comment, got you gone? Is that what he said? Oh, got you gang. Um, again, they withheld and we've already talked about that. Oh, I've already done that. Okay. So now we're on this page. I've already got 3 pages of notes, front and back. Then Mr. Proctor stated that it was responsible for the crime scene. He is responsible for the crime scene. Mr. Proctor at Sally report, not a crime scene. He responded, excuse me. So that's something that's a technical, depending on how you look at it. Mr. Proctor said he responded to the crime scene. He is calling the crime scene the Sally Port and not 34 Fairview. So that's how he's getting out of that discrepancy. He never responded to 34 Fairview Road. Until the federal grand jury, Michael Proctor testified, nobody knew of the videos. That was only gleaned from the grand jury testimony of Michael Proctor. And he said he had viewed the footage. And then he said he viewed all the footage. And then he said, the prosecution said, well, we didn't know about that. Well, just like Auntie Bev said, all for one and one for all. You're the prosecution. The police department falls under your authority. If the police department knows something and you don't know something, that's bad on you. You should know it. So that's how that rolls. Michael Proctor walked out of Canton PD office. There's video of him walking in and out. Michael Proctor, the grand jury testimony testified, I saw one grainy video, and then he said he saw one video with him and Butnick. Later, he said he viewed every video, and there were a lot of videos. See the discrepancy within his testimony for the grand jury. Before any of the taillight fragments were found at 34 Fairview. Okay? These videos, the car was at the Sally Port prior to them finding any taillight. Remember, I told you they didn't find it until at 5:54 p.m. There has been a lot of time that's unaccounted for with that vehicle. Didn't know of a 30-day overwrite on the video surveillance in the Sally Port system until a few weeks ago. That's the defendant. I think all of them, he said. Getting dribs and drabs of videos for months when the prosecution even though the prosecution said they were not aware or the videos were not acceptable. He brings something up in the affidavit. It stated that they talked about the prosecution didn't know, but yet 3 people signed the document. 42 minutes missing. We've already talked about that. And then we are now at break. I find it interesting that Auntie Bev is being so snippy about the prosecution putting on their argument and interrupting them wanting information within the argument when she could take notes. And when he's done, she goes, okay, I have questions. Where's this, and this? Tell me why this. I think Auntie Bev realizes, I hope she realizes that she is under extreme scrutiny. Extreme scrutiny. You guys, please share this. If you share it, what I shared, there was a second drawing today. Not only will you get in for the end of the month guarantee, but you get an additional chance for an entry using the like Karen Reed can't help our rewatch too. Yep. Please do all that. I want to thank everybody on X for watching. Please comment, give us your thoughts. I should be able to see them. Let me pop it up. Let me see if there are any. Yeah, even Brandy says, I'm shocked to see how Judge Canone, Auntie Bab, is responding to Jackson right now. Maybe I shouldn't be, but after what she's allowed Brennan, seeing this is just wow. Lawyer, you know, boy, a combative start with Reed's motion to dismiss. We have an atmosphere here where no one believes anything anyone says. This isn't how it's supposed to be. We need to be better. No one is going to be confident in the outcome of anything in this case. Everyone's sense of another person is lying, and I get it. The judge is the one who's supposed to get it under control. Yep. So, Auntie Bev's sidebar and grill. Okay, someone's saying Bev is doing everything she can to hide the ball fanning and keep interrupting Alan's flow, especially when he is chugging along, taking out McLaughlin, Lowley, and Proctor. She's beyond complicit to the corruption. Well, here's the other thing. When he was talking about the situation with the bailiff or the juror, he's saying that it doesn't matter who. Well, I got to get back to that. I'm sorry, y'all. I didn't even talk about that, did I? I don't know if I even wrote it down. I can go back to the beginning and we can rewatch it. We have time. The juror testimony, misconduct. He's saying that the court officer, he learned of a situation in sidebar about a juror, and Lieutenant Fanning by the court officer, then by McLaughlin. The juror may be on recording saying something about the case. The juror said not talking about the case. Okay. Lieutenant Fanning is a trooper's support of Trooper Proctor. Okay. So Lieutenant Fanning is actually a supervisor to Trooper Proctor and other of the people who are testified or interviewed in this case. Trooper Fanning was included in the text chain that Trooper Proctor sent to everybody talking about the nude photos, or were there any nude photos of Karen Reed? And there were not. And that is, Miss Canoni said all of that's not true and move on. I was like, you can't do that. You let him make his argument. If you don't find in his favor, that's one thing. But she is so defensive right now. It is literally buzzing my brain. Okay, Nick. Okay, listen to this. Nick Ruku, the judge in the federal court today said he will try and make a fast decision based on the arguments today, which have given enough time for an expedited appeal if either side would like to do that. One thing for sure about the Karen Reed habeas argument this morning in federal court, no matter which side prevails, the ruling will be appealed the First Circuit. More briefs and arguments will be necessary. Hard to believe that all of this gets done before Reed's second trial. And I don't disagree with that. I keep telling you guys, April 1st is going to be a Reed April Fools. She's going to be, it's all April Fools. Yep. Canton PD on March 4th of 2025 to all media from Helen Rafferty, Chief of Police, Canton PD. I recently spoke and was informed by the U.S. Attorney's Office that all aspects of the federal investigation initiated by her predecessor and related to the death of John F. Keith have been completed. The investigation is no longer active and will be closed. Due to ethical limitations, I cannot comment further. Boom. There you go. That was released yesterday. So, yay for that. Not what we wanted to hear, but yay for that. Sorry. So, that is where we is. I'm trying to just kind of keep up with everybody's stuff. Breaking news. Hank Brennan has just said in court that he has permission from the U.S. Attorney's Office to say that there's no longer any federal. Yeah, we've already heard that. Ian Runkle, the cross-examination on June 6th, Trooper Butnick. Yes, y'all got to see this. I saw this. This is why captioning is not always good. On cross-examination on June 6th, Trooper Booty Naked admitted to. I get that all the time. That's what I get every time you say Butnick. Judge Canone says AJ signed his motion to dismiss. That talks about Fanning, and Canone says Jackson was told Fanning wasn't in charge of jury. Jackson tells Canone, that's not true. Fanning certainly shouldn't have had any access to the jury. Why, Lieutenant Fanning of all people? Oh, yes. Yeah, this is true. Judge Canone's disdain for Jackson is palatable, as is her desire to remove him from Karen Reed's defense team. The hypocrisy is clear when comparing her to the uninterrupted latitude she gives Hank Brennan to her constant interrupting of Jackson's presentation. It is. It's disgusting. And it is uncalled for. By far uncalled for. Yeah, and that's something else. As a judge, even if you don't like somebody, you should be able to hide and mask those emotions. She can't even hide how badly she wants to get AJ on an ethical violation when there is quite clearly not any ethical violation. She interrupted him, and then when he destroys her point, she has no answer other than what's next. Yeah. Do you remember the day that Fanning approached the bench before the first juror was booted? Who escorted her out? Fanning. And why does Auntie Bev keep asking Miss Little to look up stuff like she's her little personal assistant? She's addressing her like someone who she can push around and has no standing in court. Well, she can. And then here's something else. I swear the defense has to have receipts for everything. And Brennan can get up there and bold-faced lie to her, and she doesn't blink an eyelash, even when the truth is presented. This is definitely a circus court. I wish a higher court could step in, but they're not. They're not stepping in at all. And that to me is a very sad, sad point. It's horrible. Let me see any comments. No. So please, guys, like, subscribe. If you are on another platform, hop on over to the YouTube platform. Just even you just come in to like or subscribe and go back to X, that's fine. I appreciate it. Excuse me. This is when I wish a petition would actually do some good, but unfortunately, even though there's a petition, hi Gabby, there is a petition out there, it won't do any good. I know. I know, Haley. It goes through her first. I would have loved to have been in that federal court. I'm looking forward to see what happened in that courtroom. What would you guys think would happen if they kicked this out and the federal court sided with the defense? I don't think we have a snowball's chance in hell, but who am I? I am very fearful that she's going to go to jail. No. Understand. I'm going to approach this trial like I did last time. It's a new trial. I don't know what's going on. No, mine's fine. Yes, they were supposed to come back at 1:45 Eastern. That's 12:45 my time. That's 13 minutes. I'm watching Diane interpret for her class. It's a financial class. Y'all want to watch her interpret for a class? I feel bad for her. It's not hard. I understand you told me it's hard mathematics and numbers twice. I know. It's the amount charged times 2. Yeah, that's a hard job to sit there and interpret all that. Yes, they were taking a 45-minute lunch break, which means they should be back in 12 minutes. Oh. For those of you who are just hopping on, I appreciate you guys coming in. I appreciate all of you who have stayed. I'm just going to take those out and move that over somewhere else over here. I am sorry. I am not up to my usual self, and I'm in dark mode. I woke up at between 5 and 6 this morning with a raging migraine. Today's the 5th. Is today Wednesday already? Tomorrow I have my concert now, guys. Whatever is happening tomorrow. I am out at about, I think, 3 o'clock. I will be out. I have to get ready. I have to drive to San Antonio and all that stuff. Well, thank you so much. It's eased up. That's why I'm here. I took medicine and I'm kind of nipping in between because of the medicine. I don't want to get nauseated. Okay, so now in the Fabio Cimitilli trial, which we'll watch after this, is on right now. And it is that still Oh, let's see, the Cimitilli trial, is that still going?
You're gonna tell them the truth, right?
Yes.
But one
He's
thing you
back
didn't know
on
if
the
they
stand.
had was any evidence tying you to Miss Simontilli.
I figured they probably combined everything. I just didn't tell them everything until I got an attorney present to advise me on the proper way to proceed.
And that's fair.
Well, you asked for an attorney while you were up in Vancouver, didn't you?
I did.
They didn't give him.
Site here where it says talking to the Perkins guy.
Objection is hearsay.
I haven't really heard the question. Are you going to bring in a statement?
Statement of Mr. Austin.
All right.
Mm. Sorry, guys, I'm trying to get the Cimitilli set up. Because as soon as this is over, we're going to go into the Cimitilli trial. It's heating up, y'all. It's heating up. I'm going to schedule it for today at 5 p.m. Doesn't mean that's when it's going to actually happen. We'll just have to see. We'll just have to see. I just need to get it up and going and set just to make sure that I have everything lined up so then I can just transport y'all over there when we're done with this trial. I've got so much stuff on my background, it's not even funny. Let me close this one out. Bring this one back. There we go. We can zoom.
Attorney, remember that?
I remember seeing that in the form of a question.
Okay. And you talked to an attorney up there, right, about extradition?
Yes, sir.
Objection Vegas and time.
Okay. So my question to you is, they told you
What do you mean,
that
Haley
they
Mouse?
wanted to talk to you then, up in Vancouver, if you were willing to talk to them. And that's Mustagel, Detective Byers, Detective Farrell. Remember that?
Yes, sir.
So you had a choice. Either talk to them or not talk to them, right?
Yes, sir.
Okay. Now, you had already been talking to the Perkins individual and saying all sorts of things about what you did and so forth, and what you should do and whether you should get the bitch and talk about Monica and all that. You already had those conversations with the Perkins individual, right?
Yes, sir.
Okay. But you didn't know the Perkins individual was working for the police and was going to tell them everything you said.
Nope.
No, sir, I did not.
You didn't know that that was all tape recorded, so they would end up knowing everything you said, and we'd end up knowing it. You didn't know that either.
No, sir, I did not.
Okay. But you thought you had a choice, your own choice, whether to speak to the detectives and the DA, Ms. Stagel, or not, right?
Yes.
And I read you a lot of quotes yesterday where you basically were saying, both to the Perkins guy and to the DAs, I got to get back and see my daughter. I got to get home and see my wife. That's the only way I'm going to do it. So I'm going to talk to you, right?
Yes, sir.
You even said, tell me what you need, right?
Yes, sir.
What did you mean by tell me what you need?
I don't know how else to say. Like, tell me what you need. You need me to stand on one foot? I'll stand on one foot.
Okay. Well, they didn't want you to stand on one foot, but they wanted you to give them evidence against Miss Simontilli, right?
They wanted to know the truth of what happened.
Okay. And did you tell them the whole truth as to what happened?
Not when I was in Washington.
Okay. But you did tell them about what you did and how you killed Fabio Simontilli, correct?
I did tell them my participation.
And you told them about Mr. Baker's participation, correct?
Yes, sir.
He got you into it, right?
Via defendant, yes.
Via the defendant.
Yes.
The defendant asked you to kill Fabio Simontilli?
Through Baker, yes.
That's what Baker told you, you say, right?
Yes.
And you told
Okay,
that
Haley
to the
Mouse. I
police.
apologize.
Yes.
Brain cramp.
You told the police
Thanks, babe.
and the detective up in Vancouver that Miss Simontilli was involved?
I don't think I told them that until I got here.
Okay. So that's my question. You asked them what they needed, right?
Yes, sir.
And you knew they needed Miss Simontilli. They, the bitch is the only one they don't got. She's going to trial. Baker's already been convicted, blah, 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 right?
Based on what the information they presented to me.
So you knew the only one they did not have any evidence against was Monica Simontilli.
I did not know that.
Sustained.
I was unaware of it.
Well, then you tell me, when you talked to them up in Vancouver, you told them that you killed Fabio Simontilli, correct?
Yes.
You told them that you did that because Mr. Baker asked you to do it, correct?
Yes.
You told them that Mr.
I had to
Birdsong
tighten
was
my mic.
involved, correct?
I know,
Yes.
right?
But
Poor
the whole
son.
time up in Vancouver, you never told them that Monica Simontilli told Mr. Baker to do it or had met with Mr. Baker or had anything to do with it. Isn't that right?
Yes.
In fact, you told them that you didn't even know you were going to kill him. First thing you learned when you landed in LA was we're just going to rough him up a little bit.
Yes.
That was a lie.
Yes, it was.
Well, why did you tell them you were just going to rough him up a little bit and then tell them that you stabbed him in the neck?
Have you ever been pulled over with six people on your way to work, and then 2 detectives come talk to you?
I'm trying to remember. No, sir, I have not. But I'm just
Okay.
asking about what happened to you. And I'm talking about up in Seattle, not being pulled over on the way to work. In Seattle, or Vancouver, I'm sorry, you had several detectives these two gentlemen here, correct? Bias and Farrell.
Yes.
They didn't mistreat you, did they?
Not to my knowledge, no.
Well, you were there.
No.
They didn't drag you out of a car or anything.
No, they did not.
Miss Stagel didn't drag you out of a car or anything.
No, she did not.
Okay, they had you in a room, right?
Yes.
And they made it clear all they wanted was the truth, and they made it clear they needed evidence against Mr. Mintilli. Right?
Sorry, Your Honor, objection, compound. He didn't know how to answer that.
They didn't
It's a compound, Your
mention
Honor.
that. They said,
Ding, 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 ding,
we
ding,
know
ding.
what
Save your
happened.
man.
We want to know what happened in between.
And when they said, we know what happened, you assumed they knew everything about the case, correct?
Yes, sir.
Including the involvement you're saying now and yesterday of Miss Simontilli.
Yes, sir.
So all you were doing up there was confirming to them what you thought they already knew.
Yes, sir.
And you did confirm to them what you thought they already knew, right?
Yes, sir.
You told them about flying down, correct?
Yes, sir.
First you lied and said it was for roughing up, but then you
Remember,
changed that,
don't forget,
right?
you got special emojis you
told
can
them it was
use.
a plan to kill him, correct?
Yes, sir.
And the plan was with Baker and Birdsong, correct?
Correct.
Yes, sir.
And you went out and you bought, first you said one knife, then you said two knives. Did they buy one knife or two knives? Okay.
Don't remember.
And you told them everything about the murder, including your guilt in first-degree murder by stabbing him in the neck, correct?
Yes, sir.
But you left one thing out with them.
I left a lot of things out with them.
You tell me what you left out.
Oh, good one.
I left out the day I landed. I left out.
I'm sorry, what?
I left out the day I landed. I left out
The
what
day
the plan.
you landed, you left out? You didn't tell them you flew down and then you went to the house and Baker told you that he was just going to rough him up? You told him that.
Yes, I did.
You told him that Baker paid for the ticket, correct?
I did.
You told me you were coming down the day before for your birthday?
After.
What did you leave out that was important?
I
Time.
left out the night that we got there, that he was supposed to go to the store and get some food.
Okay.
I left out.
Hold on 1 second, please. Glad you brought that up. When you were talking to the detectives up there and even to the Perkins guy, did you ever mention that what you're saying now, that the night before you went out there with Baker to try to kill him?
No, I did not.
And why not?
Again, I didn't have an attorney present to advise me on proper counsel.
Okay. And then when you got an attorney
I was winging
down
it.
here in Los Angeles, then you told him for the first time that you had been brought out there the night before, right?
I told him the second time he met with me, everything.
The second time you met with you. You didn't tell him the first time.
Not in like complete full detail.
Did you lie to him the first time?
Didn't tell him anything the first time, so I didn't lie to him.
Well, eventually you ended up telling the prosecution exactly what they wanted to hear. Isn't that true?
The truth?
You told them that for the first time up here that Monica Simontilli was involved some way in the murder, correct?
Yes, sir.
Even though you had only met her at the gym and at the LA Fitness, correct?
Yes, sir.
Even though you had never spoken to her other than to say hello, correct?
Yes, sir.
Even though you were never looking at the phone or any text messages when Mr. Baker was talking, correct?
How do you mean?
You never saw him talk to Monica Simontilli where you heard her voice or you saw text messages.
That is correct.
So what you told them was that Mr. Baker had gone into another room, sometimes was talking and came out and said to you, she wants him dead. She's giving me information. She's telling me what she wants. That's what you told them.
That's what I told him.
For the first time.
Yes, sir.
That you had never told him in Vancouver to the Perkins guy or to the officers there.
That is correct.
And the reason you told him that was if you did not tell him that, and you knew this, you were not going to get a deal. Isn't that right?
No, that is not right.
Well, you hadn't gotten a deal yet before you brought in Miss Simontilli, had you?
No, I did not.
It was only after you mentioned Miss Simontilli that the district attorney's office said, we'll get back to you. And then a few days or whatever, they came back to you through your attorney, and then they made you this offer.
Wasn't a guarantee that I was going to get one at all.
No, it wasn't a guarantee. Depended on what you said, right?
Yes.
And you knew at that time, whether it was from your attorney or anywhere else, you knew you had to tell them that Monica Simontilli was involved in some way in order for you to get your deal. Isn't that right?
I knew I had to tell them the truth, sir.
Okay. And you're saying that's the truth now.
That is the truth.
And you, for the first time, said that you went out the night before to kill Fabio, correct?
Yes, sir.
Why didn't you tell them that in Vancouver or to the Perkins guy? Didn't involve her.
I did not have an attorney present to tell them everything.
So you told them that you stabbed him and you killed him, but you didn't tell them you went out the night before and did nothing.
That is correct.
Why would you leave that out?
I did not have an attorney present for proper counsel.
Did you have an attorney present up there when you confessed to first-degree murder?
Objection, seems facts not in evidence.
Sustained.
And illegal conclusion.
That's sustained.
Did you have an attorney up there when you confessed to stabbing Fabio Simontilli in the neck and killing him?
No, I did not.
Why did you tell him that without an attorney?
All the years I spent working with high-risk youth, I always told them, I was like, I can't ask you to do anything that I'm not willing to do myself. And they got to stand in it. And so that is what I did. I stood in what I did. And I let the chips fall wherever they may.
You told the truth.
I told a partial truth.
Well, you didn't have an attorney with you, right?
Objection, asked and answered.
Yes, it is going over.
So you told them a partial truth, which was you committed murder by stabbing somebody in the neck, correct?
Objection, asked and answered.
I'll allow this question.
Yes.
And the partial you left out was any evidence involving Monica Simontilli. Isn't that
Objection,
right?
asked and answered.
Cumulative, sustained.
Okay. The whole time you were up in Vancouver without an attorney, and you're saying you told them the partial truth. In other words, you left out Miss Simontilli, correct?
Yes.
You told them that Baker told you you were only going up there to rough him up. And he told you that the day you landed at the airport and drove over to the Simontilli house, correct?
Objection states the testimony.
So we're on.
Can you ask that again, please?
You landed in Los Angeles the day before the murder, correct?
Yes.
And Mr. Baker at some point drove you up to the house where Mr. Simontilli, you were told, was home alone, correct?
Objection, Vegas is time.
So we're on.
When I landed,
Was it that day or the next day?
it was the next day.
Okay. Between the time you landed and the next day, did he change anything about you were going to kill Mr. Simontilli?
Objection, Vegas.
So we're on.
What do you mean?
The next day, did you go to the house with him?
I did.
And you put you in the trunk and you had knives and all of that, correct?
Yes, sir.
And why did you go there that night, as far as you knew that day?
Objection cumulative.
I love this.
We are still waiting. They're already 15 minutes behind.
With all the detail that I knew already, Baker said, I'm not going to let anything happen to you. Trust me. Just go with me and I'll take care of everything. So I went with him.
But you left something out, what Baker told you, didn't you?
I left a lot out what Baker told me. Baker also told me not to mention her.
Okay, not to mention her, right? But he also told you that you were just going up there with him to rough him up because she'd been mistreated by her husband, correct?
He told me that he was abusive.
Thank you so much,
He was
Haley. Now,
abusive, and you were going there to rough him up.
thank you.
That's what you told the detectives up in Vancouver, and you told the Perkins guy, correct?
That is correct.
Was that the truth?
If we get 12 more members, we get 13 more or a bunch more customizable emojis that I can create for you guys. No, you haven't, love. Thank you so much. You are so sweet. Y'all really are. You have no idea how much I appreciate y'all.
No, it was not.
Why did you lie about that?
Because I did not have an attorney present to give me proper counsel. And I didn't know them to tell him anything in the cell.
And then you went on and told them that you stabbed him in the neck.
After I talked to the detectives.
Did you change it and tell them it wasn't just to rough him up, it was to kill him?
I remember telling him it was to rough him up, yes.
Well, how did it get from roughing him up to killing him? Did he resist in any way?
Who?
Mr. Cimentilli.
I forget that I can do that.
A little. I think a little, yeah.
Well, how did he?
But Baker started stabbing him already. So.
How did he defend himself? You remember?
I remember he was sitting in the chair.
Okay. And?
Baker had already covered his mouth and pinned him down to the chair.
He had what?
Baker had already covered his mouth and pinned him to the chair, and I had already covered his eyes, and Baker had started stabbing, so he didn't have a chance to really defend himself. It happened really fast.
1, 2, 3, boom, you got in there, right? He wanted it fast, Baker.
Yes.
And 1, 2, 3, you got into the Porsche, right?
About that, yeah. It was quick. It was really fast.
Really fast. But it wasn't roughing him up. It was killing him.
All right, now we are back to the Karen Reed and the fan. It looks like it's been cleaned, y'all. Oh, the fan has been cleaned. It doesn't have dust bunnies. Oh, hey, kitty. I didn't know you were under my chair. Let me move my tinny so you can get under there. Yeah, there you go. Kitty is starting to come out a little bit more. Kitty. There we go. She was under there. I don't know why she's doing that, but she is. But she's in here with me at the moment. Kitty's been behaving weirdly. Hey, Miss Diane.
Joey, now you'll probably have a couple demon seeds by then in the basement. That's okay.
Oh, okay. So she checking in with me. Oh, yeah. It's either I'm hot or I'm cold. I can't get comfortable. It's the headache. Mm. So it's been a rough week for a lot of people. And I think I got the headache because of all the dust and everything that blew in. Um, we had high winds and dust. We were Dust Bowl. And I got to tell you, I never understood how bad the Dust Bowl was until I researched the Dust Bowl and how many people died because of it. It was horrible, y'all. So much lung disease and everything else. So they turned the fan off. Yay, it finally stopped. Okay. Thank you guys for hanging with me. Those who did. I know that it's kind of blustering and difficult, but the Karen Reed is going to be back any minute. Let's see if some food and some drink helped Auntie Bev get in a better mood. Honestly, I strongly doubt it, but we will see. It is very, very disheartening to have a defense get up there and start his argument. And most judges will let you just do it. Now, if you're going on for 2 days or day and 3/4 or 2/3 or whatever, like the prosecution did in their opening statements for the Simatilli trial, I can understand them saying, and how much longer do you have? But Auntie Bev doing what she's doing is frustrating. It's beyond frustrating. Hey, I see you, love. I see you. Hey, babe.
Hey.
Are you done?
Can you see me? Hi. How's it going?
You're so excited. Why are you so excited?
Wonderful. Look at my girls.
Wait a minute. Are you talking to Ada or grandbabies?
I'm talking to grandbabies.
Well, I was wondering why you were so excited looking into the camera at me. I'm like, dang, I wish it'd be nice for someone to be excited over that. You go love on your grandbabies. He's loving on her grandbabies. I thought she was excited to see me. Now I'm disappointed. I would love for to walk in the room and somebody be that excited over me being there. I know. I'm disappointed. I'm like, well, what about me? Yeah. Actually, before we really started FaceTiming and stuff, we go a year without seeing each other. We talk on the phone, but we go a year without seeing each other. And as some of y'all heard yesterday, the conference that we always interpret and that we always go to is not going to happen. They have an international one year, and the opposite year, they have a national conference. And so the organization is restructuring, and so they're not going to have their international. And let me tell you, people come from all over the world to that international conference. And yeah, from some countries you didn't even realize were there. But anyway, we would only physically see each other once a year, and we would be that animated for about 5 minutes. Oh, y'all, I'm so excited for tomorrow night. I'm gonna go to see CC Winan. Y'all y'all don't know who CC Winan is? I can't believe. Um, let me just show that I'm not going to show her video because I don't wanna get a copyright strike. But this is CeCe Winan. She used to be best friends. I mean, like sisters to Whitney Houston. And CeCe Winan has had her career in different genres of music, but gospel is her favorite. And some of her most popular songs are listed here. But she is a fabulous, fabulous woman. Here, let's see. Priscilla Marie Winan Love, known as professionally as CeCe, born October of 64, an American gospel singer who's garnered 17 Grammy Awards. That's a lot. The most of any female gospel singer. She's got 31 GMA Dove Awards, 19 Stellar Awards, 7 NAACP Image Awards, 4 Billboard Music Awards, along with a lot of others. She has been influential in so many places. She's done gospel, contemporary R&B, worship, contemporary gospel. She has 19 million records and sales certified by RIAA. Years active. She started professionally in 1980. She sang with her family, the Winans. Then she went out in like 1995 on her own, released her first record. So in 1984, Lord Lift Us Up. That is when I found out about her with her and her brother, BB. So she's a very, very well known books, personal life. Oh, these are all of her songs that she. So she's huge. She's huge. And I am getting to go see her tomorrow. Tomorrow. We love you. Tomorrow. I don't get to go to concerts, and they are going to have an
Sergeant Buchanan, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know if it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally. Perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them. And that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchanan with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth during this debacle had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchanan under direct examination by Mr. Lally, going into the next day, still under direct examination by Mr. Lally. They played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least in its initial comments to me, was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that, that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. He's on the other side of the car. That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of a camera, and then when the Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
And you cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutors sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this
Taylor.
same issue, the Commonwealth recites this now worn out sentence: the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
And what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth in a report from Sergeant DGM Petro. He reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is It's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting. This is the first we're hearing of any of this last Thursday. How is that? Sure. Ms. Lewin just handed me a clean copy of the DG and Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes.
You probably did.
So I've seen it.
Okay. May I approach?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if that's
Sure.
all right, Your Honor.
Sure, I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes. So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
Exhibit 1, so marked.
Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DG and Petro, he downloaded every single bit of video of that car while in the Sallyport or while at Canton PD and Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DG and Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out for the first time that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG and Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is, Chief Rafferty
I can't
held
write
on to it.
enough.
She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition
Yeah, that's huge.
of bad faith. And it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. We received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, O'Rourke, DG, and Petro.
What are y'all's thoughts?
These individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchanan's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022. He knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added Canton PD 12922, and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony. So it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. Exterior Sally Port. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sally Port, which was grainy and had a camera vantage point from the front of the Sally Port. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sally Port camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have.
Whoa!
It does have one highlight.
Go,
on it.
Jackson! Go!
May I show it to Mr. Brennan?
Go, Jackson, go, go. Oh. There's a lot of information being here that we've not
So
really
you do
heard.
have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought
get
Mr.
one.
Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
Do you have an extra copy? Is that one clean? No, that was the only copy that I've got.
May I approach, Your Honor?
Please.
This one has highlights on it. I apologize.
It's okay. Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sally Port videos? Who does he say was requesting the Sally Port videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason it could have been Trooper Proctor. Seems to be reasonable, but I don't know because Trooper Buchanan doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing.
There's no way this thing's going to be in trial by April 1st.
Michael Proctor was receiving the footage directly from DGM Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back.
Okay, I got to grab that name. I keep missing that.
Dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with because we didn't have any of the evidence that had been secured concerning that Sally Port. Question. There's surveillance video from Canton Police Department Sally Port garage that wasn't turned over, right? Answer. That video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing
I'll
she
provide that to you
can.
in just a moment, Your Honor.
June 10th?
It was either June 10th or June 12th, but let me double check.
Well, she's looking for that, Your Honor. May I
Please go
proceed?
ahead, yeah.
Okay.
That
The
is her
only thing
job,
it's
though.
important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the Sally Port that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it and he received it, according to Sergeant DGM Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible, with all this sort of years-long flurry that we've just talked about surrounding these Sallyport videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor. And then we move to January 28th, 2025 this year.
Sir.
We're still getting additional video.
Those of you who are just joining and don't understand why I got excited over that, when he's
Video, however, is that the prosecution now admits.
When he started yesterday, she made a comment about their complaining or saying that, well, this Miss Little did this, Jackson did this. She said, you are all for one and one for all. If a mistake or comment or whatever is made by one, it's made by all. He is now using that which was thrown at him yesterday against the prosecution, and I'm all for it.
Quote,
She can't
after
take it back.
inquiry, it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went and why we don't have them and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. but it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith. And this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument. But the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional. Prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass.
Using
298, 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and finds that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial.
Yep.
The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession. And it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though. And it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time.
Thank you
Like I
for
said
the
before,
nothing
it
to
defies
whoever's
logic.
sending it.
For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
I understand that that does not help the defense.
It doesn't help the defense. And I appreciate the court finishing my thought on
She's
that.
like,
It's the
hurry
opposite.
up and shut up. I'm done.
The
I
only
already
remedy
know what
that
I'm
can
going to
prevent
do.
this kind of repetition, this kind of
For-
misconduct
I
is
found it.
dismissal. That's the only remedy available. And that's what
Oh my
law, the law, and that's what justice demands.
Oh,
As a final thought,
thank
if the
you.
court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your
He's
notes.
putting
But
down
Ms.
his
Little,
book,
did you
ma'am.
find the
Yeah.
Proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just
Okay.
for the court's reference, lines 8 through 12.
Great.
Thank you.
I have a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, And again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dayton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No,
As Dayton Police, Barrows testified. All right, where do I find that 47 pieces?
The 47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial, that there were that many pieces found at the crime scene.
It's the number of pieces that were booked into evidence.
Okay.
Yeah.
Great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it, because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight recovered at the
That's not clear to me the way this is written, so I'm glad I asked you. Okay. All right, so with that, now, Ms. Tinetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense, so I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sally Port videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand, and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September,
I gotta do
had
this.
found
Sorry, guys.
the
I'm trying to
letter from Chief Rafferty.
And I missed that.
In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory.
That's not for you to decide. Whoa. That is not for you to decide what is relevant or not relevant to the defense. That's for them. Pissing me off already.
Make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Okay.
At that point, there had been no request by the defense for video of the Sallyport area. What I learned is that Trooper Proctor had requested Sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police video who would download it from the DVR was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Sally Port and camera in front of the police station. That remained with Trooper Proctor for some time.
Yep.
In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro.
Even though we already had it?
For different cameras. He wanted cameras, camera angle of outside the Sallyport area. So when the tow truck dropped the car off, leading into the Sallyport, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the...
My question is this. You're nailing your coffin for me if I was a judge, because here's the thing. You guys sat there and told their investigator that after 30 days, everything was written over. There was nothing to be had, and the judge denied the $24,000 reimbursement to the defense from the prosecution. But now you're telling me that in the September 24, more than 2 years after January 29 and 22, the date that Proctor was killed, O'Keefe was killed, 30 days after that would have been March 1st. You just shot that wad right out the window, dude, because you're sitting here saying you're producing videos 2 years after, but yet almost $25,000 refund was denied based on other evidence. I am getting livid.
CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified or was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any
doesn't matter what your
specific
intent
interest
was.
in. There was no particular.
What was good for the geese is good for the gander. It doesn't matter. He's a representation of you. He had it. You should have known it. You say you didn't know it. Too bad. Hello. Are we looking at the oh my gosh, I just lost his name. The actor got his charges dismissed because the prosecution and their employees did something wrong. Alec Baldwin case.
Discovery request
Evidence log.
by the
Handling.
defense,
Why
there
is
was
there
no
just
order.
a posted
Upon
note?
reading
No
that
evidence
grand
back.
jury testimony,
Exactly.
ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022.
Can't
I'm
write
sorry.
quick enough.
It was provided April 4th, 2022.
2022 or later?
No,
It was later, right?
was
Because
later.
the
It was-
federal grand jury was later.
he provided it on the eve of trial. So it was April 4th, 2024.
Of trial.
So we know this production on April 4th, 2024 was in the hands of Trooper Proctor in shortly after January 29th,
Exactly.
2022.
What about the evidence log? Come on, dude.
At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior Sally Port. As trial began, there still was no specific order or request. The chief of police saw something about the trial, and let me rephrase. Prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera Sally Port was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yannetti's concerns, then asked Sergeant D.G.M. Petro to see if there was another camera or to produce any other video from the Sally Port. Sergeant D.G.M. Petro then downloaded video from the DVR, which is the second camera that is inside the Sally Port, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior Sally Port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Sally Port and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives. And because of the backup hard drives, the video existed longer than 30 days. She wrote a...
Whoa. I gotta. So he's dancing, even though I can't. Okay, I can't write that fast, and I'm burning through the paper. So you're telling us that after the trial, a person, I didn't catch the name, went and looked. I'll put a sergeant, I think, went and looked at the system, and the backup disk had more video, even though there's a 30-day overwrite. So you're telling us, again, the defense and you had a conversation that you would permit their investigator to come down and y'all go through all that and record that process. And when they got there, you said, oops, there's nothing. And then they put a motion to be refunded $25,000, 24 plus change, for your bullshit. And you're standing here today saying in June after the trial, or was it July? Doesn't matter. Before that request was made in December, you're telling us that y'all found more evidence on that drive? So did you delete it after? You didn't just turn it over to the defense. What the hell?
Extensive report that was turned over to the defense, and this is after trial. The report notes her investigation.
That's exactly it. Passing the
about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial. And it is noted in the sergeant's letter, the chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion, or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately.
No, not false claims against them. They were doing it in preparation for an inquiry into the department, and there's a federal investigation. They were doing it to cover their butt. Ooh, this is pissing me off. It's just pissing me off.
The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it. I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned about the videos. And then as a consequence, I spoke to the chief, other officers, and the sergeant unexpectedly. The sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything. So I asked
Again, he admitted
that
no
the
written chain of
parties of the
custody.
Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Buchanan to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Okay.
This is not going to help him for
Your
his
Honor, I have
review he's
3
under.
separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Okay. Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. They have produced absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which is about 3 sentences. But if you actually read a number of pages of his testimony that deals with this video, and it begins on page 133, what you will see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton police. And you can
That may
also
have been a
see
slip.
that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Sallyport video, and also there's an exterior video outside the Sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sallyport and there's the exterior video. So clearly Trooper Proctor was aware of the exterior Sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course. And so it's important that although the defense now suggests there's something
Are we seeing Alec Baldwin all over again? Doesn't matter. Doesn't matter who knew about it when it comes to the tree of the Commonwealth. They should have known. Proctor works for them. They are responsible. His admissions, if they don't dismiss, I'm going to go freaking ballistic. I'll
Exculpatory
drink
about it
that
or
bottle of
something
champagne
about
behind
it
that
that's
curtain.
important. It is
I'll need
important
it.
to note that the defense never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will
They
do
keep
that.
saying that.
The Commonwealth
They
seeks
did.
evidence that they think is
They asked for it.
exculpatory. They seek evidence that they think is relevant material,
Need
and
to
when they
come back
receive
on
it,
that. They
they are
need to
supposed to
clear that.
provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was a evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe. In fact,
You were
if you see
splitting hairs
earlier interviews, the defense
7
position
ways from
publicly
Sunday.
was, you know exactly who did it,
It was never
intimating that
taken.
there
The
was a
metadata
specific
should
person.
be intact and produce
Now that
that
recently has changed. If we see
a
the recent interview 2
frickin'
weeks
minute.
ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has. It's important to look at the motion that has been presented to your honor on behalf of the defense, where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for your honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard pressed now at this moment where they are trying to create prejudice that doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you've seen in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting. I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. Answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct, because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they ask you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance, because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. So you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So
do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't. Perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it
I'll
from.
provide it momentarily.
All right, thank you.
So what really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros's testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight to my best ability and recollection, that taillight was not completely damaged. It was cracked, but they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body.
After the vehicle
same
was
parts of the
taken to
taillight
your
fragments that are
Davenport,
found
and
in the sleeve of his
later,
shirt.
still finding pieces.
And so
My
it's
ass.
not simply cracked. Even the witness they tried to lean on, Mr. Barrows, says more. And so if that taillight is not just cracked, that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring, because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute.
Oh, you will.
And we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense. And I just want Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the Sallyport area. Now you can see, if you stop that, please. Thank you very much.
Well, why is it inverted? No, 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 y'all. I call bullshit on this. Do you know why? Because if a video is inverted, so will the date stamped. How do we know? How do we know that they didn't circumvent this? How do we know they didn't create it themselves just for this exhibit? I'm struggling with them so much right now because interior Sallyport back wall ... GMT 511 of 2022. If it was truly an inverted video, all of that would be inverted, in my humble opinion. Now, that timestamp may be in the computer when the image is inverted, but I don't know if I can trust this. Do you? Do you trust that this is not a circumvented video? I don't know. They are backpedaling so freaking hard.
This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that Sallyport. Similarly, front wall camera, could you please put on exhibit 3? Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sallyport. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. This is the way the camera worked in Canton. Thank you very much.
Oh.
So the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please. This is from the ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sally Port video is relevant to show any break or planting of evidence. As
She
Ms.
hits
Lee
it. It
nudges
breaks
into Mr.
there.
O'Keefe's
There's a
car,
sliver
pull
missing,
forward,
not the whole
and
thing.
we'll stop the video in 2 spots so you can get a clear look.
Okay, I'm going to say this. If you take a tail light this big, okay, and you ding a sliver out, that's acceptable. That I believe. 48 pieces, that's almost the entire freaking tail light. The size of pieces that they were showing were too big. If this was damaged, oh, he's saying she damaged it there, then she hit John O'Keefe and the rest of it fell out. That's where he's going. Oh, shoot. I know it. I follow it
Of
now.
that rear tail light missing. Forward, please.
That white is
Thank you.
supposed to be there. That's supposed to be
And
there.
then-
My mama has
and
that car. I know what
You
it
see
looks
the
like.
white light shine.
Right
Stop.
there.
You can see it clearly missing. You can't plant something that's already gone.
Nope. Then it would be left.
And the reason why you see white, it is a red tail light cover,
Oh,
and when
wait,
the
I'm
red
wrong.
is missing
You
or
hit him and
gone,
then
as it
came
is
home.
in this case, the white bulb still shines, and that's why it shines white.
My bad. I'm getting excited. She hit him, comes home. She backs up into that. So she has an alibi of the broken tail light. But there's no way 48 pieces on that tail
The
light.
defense
The size of
position
them were too big.
is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial,
Oh, he's nailing them. This
it's
is
noted as
not helping.
Exhibit 10 in our package. Page
Mhm.
36.
What do y'all think?
ADA Lally
Mhm.
asks the good doctor, now, doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant
Sorry, got to do it.
backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that taillight
That was
is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up from the court, please. If you compare the right side to the left side, although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dayton said, just like the 508 ring video shows, is missing. Is missing. There's no plant.
Well, wait a minute. That's not necessarily true. because, okay, thanks, Haley. Hi, Elaine. Thank you for hopping in. That's not necessarily true because we don't know if another Canton PD person went up there while everybody's in the house and removed parts. I'm being devil's advocate. I'm playing devil's advocate. They could have easily walked up there and grabbed parts off of that.
The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are two videos, 8 and 9. If we could play Exhibit
He's
8.
doing a good job, though. Don't like him, but he's doing a good job.
This is the defendant's car arriving in Dayton in the driveway. The defendant
That's
on the
deep.
passenger
No,
side,
y'all.
and you can see them walk to the back of the car near the right taillight and stop.
I mean, look at it.
And if the
Back
question
up
is,
in
what
the
are they
car.
stopping for? We can play video 9. And this is when the car is being put on the tow truck before it makes its Canton. And just like 508 in the driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity
That's
to stop
pretty
the video
damning,
at the
y'all.
important points, please do so.
Can you lower it?
We cannot.
Can you zoom in on it?
Oh,
I would
this is
encourage the parties to
damning.
look at it on the computer. The clarity is much better and it's very clear. The white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these
No, it's
exhibits?
red.
Oh, there we
There's
go.
some white. All right.
Okay,
Hold on.
If you look
What
at it
year
on the
is that?
small screen, see right
I
there?
do see it.
Yep, and then you'll see it again. So the alarm.com video contradicts the defendant's position that there is anything exculpatory about these Sallyport videos. In fact, this whole idea of third party or plant doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the Sallyport video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said,
All right. Hold on. I want to show you something. This is the vehicle, her vehicle. They have removed the entire taillight there, right? Let me explain. You see this white section right here? Uh-huh. Do you see this red section right here? Uh-huh. If this little section is cracked, it would give the same coloring of the white that you see. But see how high that white light is? Now, when they're saying this entire thing here busted and this whole section all the way over here is red, but when you look in the video, it's the side here. This white light is up high. It's going to be brighter than the lower. But here's my point. Here's my point. Hi, Toxic. Buenos noches from Spain. Listen to this. How in the hell, when it's only this deep, right? And about that wide, are you going to get 47 pieces of tail light? Not from either one of those collisions, y'all. Not from either one of those collisions. I am going to scream about that unless I see something different. Here's a better view. See that white right there? If this is what hit John O'Keefe's car and that little piece broke, you're going to get white light through it. But this is only about like this. There is no way When you look at the size in the photographs of the evidence that the pieces that they collected, how are you going to get 47 pieces of broken glass from that? When you're at night, or when you have a white here and you have a quarter size missing piece here and you hit that tail light, it's going to shine brighter than the red and it's going to stick out like a sore thumb. So as a juror, if I'm seeing this and in my body car knowledge, I used to do body work on cars. I used to be a bondoist. In my experience, it's damning. It's damning. It's hurting her. But I don't think that bears the weight of this entire trial. Yes. Quarter size missing piece of book would be showing. I wish I could afford to buy one of those and break it. But guys, let me ask you, did he just shoot himself in the foot? Sorry, I didn't say share screen. Did he not shoot himself in the foot
Yeah,
when he sat there
within
and
the
said
light.
that she picked out pieces of that tail light out of the housing at 6 p.m. because she was afraid it's going to get wet and short? Uh, if she did that, you wouldn't have it in evidence, would you? How would you have those pieces in evidence? Because you put that thing back together almost 100%. So how do you have all the pieces to put it back together? She took some of them out. Explain to me where you got them. Did she give it to you? Did you find
In
them?
that
Did you
testimony,
find them in the trash?
or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red
I remember
plastic is
seeing that.
missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway.
Doesn't mean she hit John O'Keefe.
And so I say to the court,
Doesn't mean she hit him.
the production should have been sooner. It should have been cleaner. There should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen, but it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is
Elena,
missing
I'm
before
not
the
nitpicking.
car makes it to the foot of the
pleading.
Sally Port, so there can be no claim. That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
Ooh, he kissed ass there. That was a good
The
ass.
claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen. Because of the collateral consequence of tampering with the jury, it would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss is not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence, just saturate.
I don't like
just saturate
with
the
this.
public. Now it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning. Not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question. One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury. Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial, As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah.
This is going to piss
Is
Bev
it
off.
standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the
I remember that.
Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
That's going to piss Auntie Bev off big time because it's now officially read into court. You can do anything about it.
I
even
didn't
if you
see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand, I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Oh, there are going to be sanctions.
Okay.
Oh, yeah. That's
So
going to
after
piss her
step
off.
one, finding a vehicle to plant the seed, and they did that very effectively. The next step is they have to identify our target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts.
Yep, that's going to piss Auntie Bev off.
After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They try to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury. and he had access to the jury. Think about what those statements say to our community, who are going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact: Lieutenant Fanning was not in charge of juror security. Fact: Lieutenant Fanning did not have control of the jury. Fact: Lieutenant Fanning did not access the jury. Fact: Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact: Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact: at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror. Fact: no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact: Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact: Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror.
That's going to go
Your Honor,
nowhere.
these claims in the motion to dismiss have a theme. Different issues,
Elena,
same theme.
that's
same
the final
pattern, same
product.
effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
Whoa, this ain't good.
If I may, Your Honor.
Yes.
Thank you.
Rebuttal.
We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference. which is what we called it. These words matter. We've claimed that there's interference. He
Get
indicates
yourself
that
out.
that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated in just a second.
Don't go
This
dramatic.
is a fact-based
I like
inquiry,
it.
one that we asked for, standing right over there at sidebar, and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't.
Thank you.
He also said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, the greatest guy on the face of the earth. I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen when somebody else identified him. Wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal. Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc. When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before. The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who was then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course, it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual courts security, the personnel security, the party's security to whatever degree that is necessitated, but maybe most importantly, the jurors' security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same thing that was just randomly picked to go report this to, was also the person that was in Miss Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet we were denied an opportunity, Your Honor, an important opportunity to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here. Let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true. But lo and behold, minutes before I stood up to do my summation, that juror is removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right. There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sallyport video and how unimportant it is. How unimportant that video is. I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sallyport videos if you're investigating a bar fight. This was the purported murder weapon. This truck is the thing that the Commonwealth suggests was used to kill a cop. You think the video of it being pulled into the Sallyport might be of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality. But I do know this. I do know this much. One guy who thought it was important, the lead investigator, he pulled it all of it. He was super, super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years. Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. Now, I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory.
Yeah, I don't want to ingrain that any deeper into your brain.
We've never, ever disputed that the light was cracked 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety, almost, except a piece was still missing. It was a piece unaccounted for.
I nailed
The
it.
big difference between a crack and the condition of that taillight, which we've now
Nailed
seen,
it.
where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone.
Nailed it. Okay, guys, I nailed that. I nailed it. By the way, Elena, thank you so much for your compliments. And you know what? I sit here for up to 9. I've already been here 5 hours. I sit here on an average of 7 to 9 hours a day. I'm going to have to eat. My hair is going to be messed with. I am real. This is like you sitting in my home in the living room and we're watching this on my TV together. We're going to eat. I'm going to have some food. I've got to have hydration. I'm going to have to get up and have a comfort break. So this is real. Unlike a lot of people who only cover things for 2 and 3 hours at a time. A recovery addict and myself, I think, are the only two that I think of that I know that all day, every day. This is what we do. So thank you for your support. Thank you for your encouragement. And thank you for your kindness. I got my sister's water bottle. My sister passed in November, so this was her favorite water bottle. Now it's mine. So anyway, we're going to get back into it, but I called it on that lens. I called it.
So yeah, it's relevant and it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick in front of a jury present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now. I remember it because I was sitting here. He asked the question. Did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of that.
I don't think I have it. Sure. We can get that for the court immediately. Also, he played a video of the grainy video showing, hey, look, some of these cameras are just grainy in other particulars as well at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. That video he just played is at the top. That's the exact same video. If it's apples and apples, oranges and oranges, why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sallyport. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's
No! Court TV, no, 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 I'm gonna have that. Oh, that's not what I want. That's not what I need. Oh, I don't want to do this. They're not covering the Reed thing today? It ended 7 minutes ago. What?
present that video as a true and correct presentation of what that car looked like and where that car was. Mr. Lally actually asked the question. I don't have a page in sight now, but I remember it because I was sitting there. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the juror. And of course,
Okay, we got it back.
Referring to that comment that was a court comment.
Stood up in rebuttal and said that it was in court advocating for my client. He then said court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on remedying that record. There was also a conversation after with court TV.
All right, so provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, where I was arguing before Your Honor. I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me, and I would just point out, and again, I only need 30 seconds, that.
You can take your time, Mr. Yannetti. You're not going to be
Well, we're all.
35 minutes.
Right, I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology
match
from
now.
Mr. Brennan. I don't expect one, but I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a site, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts, some of his suggestions that I didn't read the paperwork properly, which is wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Ms. Yanetti's remarks, it wasn't in relation to 3.6. It was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But we'll provide
For your request for the gag order? In support of your argument for the gag order?
in response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It directly related to that point, not 3.6. But I will provide the videos. Mr. Yannetti is right that the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Yannetti, but it wasn't in fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site, I'll give you until tomorrow afternoon to find the Court TV site.
Very well.
If you have it, supply it to all, Mr. Yannetti. So I'm ordering the Commonwealth if they have that Court TV site to provide it to all of us. And if you don't, provide that as well. Provide that information.
Thank you.
Thank you. All right. That's it for today.
All right, so court, please.
When are we?
You are muted.
When are we going to start seeing some response from the court concerning all these motions, y'all? We have a shite ton of motions and we have no resolve. None. None whatsoever. Wow. This got a little bit hairy. What are y'all's thoughts and opinions? I'm going to give me a split second. I'm going to try and do something. Yay, it worked. I'm a little perplexed. I is. Okay, guys, I'm going to give y'all a minute. If you hit the like button, comment I liked, LIKED. If you share the video, please comment I shared. If you do that in the next couple of minutes or seconds, I'm going to give y'all a little bit of an opportunity to get that in because I want y'all to be in the drawing. I do. I want y'all to be in the drawing. Yes, I have a footstool. I have a blanket. Y'all, I get comfy. I have a good chair. I got my little Hamish back there. Yeah. Yes, it is a very difficult skill, believe it or not. It is not easy to do. I have done a lot of regalia making this past 2 years, and I'm still working on it. It takes a lot of work. Okay, so while y'all do that, I'm going to pull up StreamYard home. I'm going to enter to the Monica Simatilli trial. We are going to go over there over there, over there. Dun, 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 dun. You guys, I'm sitting at 2,797 subs. I need more subs, guys. Please. I need subs. I need subs. It is just getting interesting. Every time I get over the 2,800, they knock me back. Buenos noches, Ada and Haley. You're welcome. Please, I'm going to take us over. Just stay on, and it should catapult you into the next one. It should redirect you. So let me get that redirect done. It's there. Okay. That live is, I'll go live in a minute over there. Right now, we are going to do the giveaways. So let me get that on share screen. Okay. This is for the I liked. Are y'all ready? I draw every Gabby. Yahoo! Okay, that is it for this one. We'll do the other one later. We are going to be going over to the other stream. Give me a split second. I got to do an intro on that. Get me up. Okay, I'm going to go live over there. You guys, thank you so much for joining me today. I hope to see you over at the cemetery trail. We have the Red Room co-conspirator back on the stand. See you in a minute. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.